Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a decision given on the anticipatory bail. The issue is whether registration of FIR is a condition precedent to grant the pre-arrest bail or anticipatory bail. While discussing this point, UP High Court Justice Nalin Kumar Srivastava, maybe Nalini Kumar Srivastava, in the case of Javed Ahmed and another versus State of UP and others in anticipatory bail petition number 1379 by 2023, decided on 13/2/2023, held that registration of FIR is not a condition precedent, or it is not necessary that FIR should be registered in cases where you apply for anticipatory bail. Right. So before reading the provisions of section 438 CRPC, all of you must understand that this provision is inserted in the 1973 CRPC with an intention to protect the human rights under Article 21 of the Constitution of India. It relates to life and liberty. Person's liberty should not be curtailed by filing false cases. So according to section 438, if any person has a reason to believe, remember, a reason to believe that he may be arrested, that may be foisted, some cases may be foisted against him, he can approach the High Court or Sessions Court, and in the event of arrest, the court may direct him to be released on bail. This is the crux of section 438 CRPC. Right. Now, let us understand the facts of the case. The facts of the case are Mr. Javed Ahmed's friend Saban Lal or Sahib Lal. Sahib Lal has given him around 17.5 lakhs for the construction of his house as a friend. He has taken 17.5 lakhs from his friend while constructing the house by promising to repay the same. Of course, he could not keep up his promise. He paid around 3.2 lakhs only. So there were some differences between them. Ultimately, on 5/1/2023, Mr. Sahib Lal and others came to the appellant Javed Ahmed and threatened him with dire consequences that if he did not pay the amount by certain date, definitely they are going to do some harm to him. They are going to fabricate cases. They are going to foist cases against him. Like that, they threatened him and went away. Agreed by this, Javed Ahmed approached the Superintendent of Police Jaunpur by sending a letter, but no action. As it is, no action was taken. Ultimately, he approached the Sessions Court and later he came to the High Court for anticipatory bail, apprehending that Sahib Lal will file or fabricate or foist cases against him. Normally, whenever such incidents to come, the state will say FIR is registered, FIR is not registered. If the FIR is not registered, no anticipatory bail. Likewise, normally even in Ongole also it happens. Routine procedure. FIR అయితే అట్స్ యాంటిసిపేటెడ్ బై ప్రశ్నే రాదు అంటారు. బట్ హియర్ అసలు పాయింట్ అంతా డిస్కషన్ అంతా అదే. జాగ్రత్తగా ఉండే పాయింట్ అంతా చేసి జడ్జిమెంట్లో వచ్చినప్పటికీ మళ్ళీ వేరే వస్తాడు, బెయిల్ ఇవ్వడు. రైట్. Here the point is, please remember, so the registration of FIR is not a condition precedent to the giving of bail as stated or relying on the case of K. Rajshekhar Reddy versus State of AP 1998. అది కాకుండా there are two other cases also. That is Gurbaksh Singh Sibia versus State of Rajasthan 1980, and Sushila Agarwal and others versus State of NCT, National Capital Territory Region, Delhi 2020. So here the important point is reason to believe. Reason to believe. So that means the person requesting for anticipatory bail, he should explain the court what is the reason for his applying for bail, and he must make the court believe that there is apprehension that he is likely to be arrested. Now, as far as this case is concerned, please remember, when the facts are taken into this case, please remember, it is only apprehension. That apprehension is also not well founded, and the appellant failed to explain how he would be implicated. Because when they checked up the case, when they checked up the facts, it is learned that Sahib Lal did not file any case against him. Sahib Lal did not approach any authority in this issue. So there is no point of implicating him in cases. No doubt he failed to 3.2 lakhs to Sahib Lal, and he has to give back the money. But Sahib Lal, he might have taken recourse to civil law, but he did not complain to any others. That means there is no material placed in support of the so-called Javed Ahmed regarding the plea. So please remember, law does not actually permit the vague assertions. Here is only having apprehension. That is not a reasonable apprehension. So therefore, anticipatory bail is rejected for him. Right? So very peculiar case where it is held that FIR is not necessary to grant the anticipatory bail. But in this particular case, the court held that the assumptions and presumptions of the applicant Javed Ahmed, they are not sufficient to grant anticipatory bail because he could not explain the reason to believe as stated in 438 crpc. So actually this citation was supplied by our friend Mr. Asif Sheikh of High Court of AP. I am thankful to him. You also please read the judgment and enrich your legal knowledge. With this I am concluding. Thank you very much.